पीछे घुसो। कुछ अच्छा तो बोलो।
From the daily list, item number 1.
Appearing virtually for this application is an application praying to refrain the respondent from withholding them to issue a personal hearing in the show cause notice, because the subject matter is a show cause notice wherein this honorable court has passed an order. The single bench of this honorable single bench of this honorable court has passed an order in our favor, directing them to release a gold bangle which the petitioner was wearing. And since they did not return the said gold bangle, they have filed an appeal which is pending before this honorable court and is coming up. The matter is coming up for final hearing on the 10th of December. So my prayer is that they may be refrained from deciding the case till the appeal is decided before this honorable court.
Where are you located, Mr. Counsel?
Lordship, I'm in New Delhi.
Who's appearing for the panel?
Well, here what happened, my lord, certain gold was seized, my lord. Now section 110(2), subsection 2, my lord, requires that show cause notice has to be issued within a period of 6 months, my lord, from the date of seizure. Now here the seizure was done in Manipur, my lord, and at that point of time, serious law and order problems were prevailing in the state of Manipur, my lord. And because of that, though the notice was issued on the within 180 days, my lord, within 6 months, but it could not be sent to post office within 180 days, my lord, and that is why they came before this honorable court invoking 110(2) of the Customs Act. The learned single judge said, since it was not issued within 180 days, my lord, so the department has to release the goods to him, my lord. Now, against that order, we have come before this, your lordship, my lord, saying that these were extraordinary circumstances, my lord. It was nothing intentional that we did not issue the show cause notice within 180 days. Now, my lord.
No, is there a provision to regularize the delay?
My lord, there is a provision for further extension of time by the commissioner, my lord. But in this case, my lord, the necessity of such extension was not felt, my lord, because the show cause was ready by then, my lord. The only problem was that because the post offices were closed, my lord, in Manipur, And there were curfew and many other issues, my lord, at that point of time because of communal violence, my lord. So we could not. Now, my lord, but today, my lord.
Is it possible for the customs to extend the show cause notice retrospectively? It was
No,
issued
Lordship.
not
There is
not
no provision.
It was not sent, my lord, within 180 days because of law and order issues. Now, my lord, that is one aspect of the matter, my lord. This is, in my humble submission, something like grant of bail pending trial, my lord. Now, this is a question only pertaining to release pending final adjudication. Now, there are Supreme Court decisions, my lord, release of goods for the reason of non-issuance of so-called notice of 180 days will not affect the final trial, my lord.
If prima facie
My lord,
you are unable to satisfy the court
my lord.
that there is any probability of the or any scope of the show cause notice, the time limit within which the show cause notice is to be issued, to be extended retrospectively. Admittedly, it was not issued within time. Prepared but not issued.
And from our office, it was signed within time, my lord.
That is all right, but then it has to be served within time.
My lord. But, my lord, the only consequence of not issuing the so-called notice within 180 days, my lord, is that we are liable to refund the gold, release the gold back to him, my lord. It does not affect the trial, my lord. The final it does not affect the final adjudication. Now, the learned single judge, in fact, the learned single judge is very categorically held in the present order itself, my lord, that release of this gold, this is only in compliance with section 110 of the Customs Act, my lord, but final adjudication will continue, my lord. And the department has completed the investigation, issued notice to them for final investigation, my lord. My lord, if I may draw an analogy, my lord, this is something like bail, my lord. My lord, whether default bail, grant of default bail on 90 days, whether it will affect the final trial. In my humble submission, it will not affect the final trial.
It does not affect the final.
It does not affect the final trial, my lord.
But what about the goods?
My lord, goods are in our custody, my lord. My lord, finally, in final adjudication, if the adjudicating authority passes an order, my lord, ultimately the gold has to be with the Customs Department. It will be confiscated, my lord. So it is only pending, during the pendency of the trial, the release of the gold, my lord.
My Lordship, there is a slight difference I would like to submit. The whole process is going to be haywire with this. The petitioner is going to suffer because, as per the directions of the Honorable Court, which has already been passed, he should have been returned the goods. Now, if they adjudicate the matter,
What is the status of the appeal, Mr. Deputy? Sorry,
the appeal was admitted, my lord. Before this
on the final hearing, my Lordship.
It is
for
about
10th of
10th of
December.
December. It is fixed on 10th of December, my lord. Well, there is an interim order of 9th May 24, my lord.
in the appeal.
Yes, my lord. 9/5/24.
22.
24, my lord. 9/5/24.
There is already an interim order permitting the union to retain the gold bundle.
My Lordship, they only got a stay till the time the matter is decided. They only got a stay on this. order.
No, there shall be an interim order permitting the appellants to retain the gold bangle seized until further orders of the court.
Yes, my lordship. That is what I'm praying, my lordship. That's what I'm submitting, my lordship, that they have been permitted only till the matter is finally decided before this honorable. That is what I'm saying.
We will
This
hear of
matter
the
will be
appeal.
decided.
We will hear of the appeal.
Yes, my
On
lordship. That is my
December.
request. That is my request, that they should not dispose of the gold, because the only purpose for their sending the.
There's no
person
question of
hearing notice is
disposing of
they
the
want to dispose
gold,
of-
my lord, but the adjudication proceedings should not be stayed, my lord. That should continue to take its own course.
That interim order is not there.
No, not them.
It is only matter of few weeks, my lordship, the appeal may be decided and then.
No,
are
no,
ready to join the personal hearing.
we will give you leave to inspect the gold bangle every week or every 10 days.
My lordship, I have a submission, my lordship. There is a provision in Customs Act under section 150, which allows them, which compels them to issue a notice before selling off the gold. But once the goods are adjudicated, when the matter is adjudicated, when the show cause is adjudicated, they will sell off the gold. They will have the power to sell under section 102B.
No, we will
Then
say that.
we will
Okay.
not be able to refrain them.
All right.
So my request is only till the time this appeal is decided, and it's only matter of few days, my lordship. It
You
can be
file an
kept
inform-
pending, my lordship.
You file an informal paper book, and when the appeal is heard, please come and argue the matter physically.
My lordship, they have asked to appear today for the hearing, today 25th of November. That is the
No,
issue,
that-
my lordship. That was the urgency. in
No,
this,
that has to continue.
application.
That is all right. That is all right. But on 10th of December, we are fixing this appeal. You please come and argue the matter physically,
Yes, my lordship, I will do
not
that.
online.
I will do that. My lordship, I will be physically appearing. My lordship, my prayer.
And
is that
also in the
time
mean-
may be-
In the
they may be
meantime,
refrained.
yes, in the meantime, you file an informal paper book.
Highly obliged, my lordship.
Please take it out. This appeal was admitted by an order of this bench dated 9th May 2024. Next, we have fixed the appeal for hearing on 10 December 2024. Next, let the appeal be listed accordingly. Full stop. In the meantime, advocate on record for the appellant shall prepare and file an informal paper book in this court by 6 December and serve a copy thereof on the advocate on record for the respondent by that date. In the meantime, the respondent has taken out a miscellaneous application. Full stop. Learned counsel appearing for the respondent expresses the apprehension that since there is no stay of departmental adjudication, comma, the appellants will proceed to adjudicate upon the show cause. Appellant. Huh? Yes, sir. The appellant they will proceed to adjudicate upon the show cause and proceed to sell the seized gold bangle. Paragraph. In the interim order dated 9th May 2024, passed in the appeal, we find that the appellants were permitted to retain the gold bangle seized until further orders of this court. Paragraph. True, comma, there is no stay on adjudication. Full stop. At this stage, we cannot even consider any stay of such proceedings. Full stop. Paragraph. However, despite continuance or conclusion of the adjudication before disposal of the appeal, comma, the appellants shall continue to retain the gold bangle till disposal of the appeal or until further orders of the court, whichever is earlier. The miscellaneous application is disposed of accordingly.
Obliged, Your Worship.
Item number 2.
May it please, Your Worship.
Yes.
Lordship, there is a delay in filing appeal, Lord, about 50 days, my Lord.
52, my lord.
On continuation of delay application, my Lord.
Yes.
My lord, this is an application for continuation of delay, my lord. Advocate General is leading this matter of 52 days, my lord. It's an intercourt appeal, my lord.
Have you served?
My lord, no, my lord. We have not served.
Let your advocate serve.
We will take steps, my lord, in this regard.
This is an application for condonation of delay, under Section 5 of the Limitation Act.
No, my lord. There is a rule, my lord. There is a rule under which intercourt appeals, my lord. There is a rule of this High Court, my lord. Chapter 3, Rule 4, my lord.
What?
My lord, there is a rule, my lord, under which we have filed this application for continuation.
Section 5 also, my Lord.
My
Section
lord.
5
Also 5, my lord. There's a particular rule under which we have filed this application.
Rule will override Section 5.
No, my lord. I'm just
Then
assisting lordship, my lord.
Section 5 of the Limitation Act, read with the relevant rules of this court. in filing a writ appeal. Full stop. The delay is of how many days?
52, my lord.
52 days.
52 days. Lists the appeal and the application. On 11th December 2024. Advocate on record, next advocate on record for the appellant shall take steps for service of this application upon the respondent in the meantime. Okay?
Obliged, lordship.
Problem.
Item number 3 to 10.
Lord, item 3 to 10 also, my lord. There condonation of delay application is there, my lord, for about 142 days of delay, my lord. The lordship has issued notice in connected appeal, my lord, on condonation of delay application, my lord, while the order dated 20th November 2024, my lord. These appeals are connected to the said writ appeal, my lord, MC 59 of 2024, my lord. It may issue notice.
You are for the respondent?
Your Lordship, in this we pray that Your Lordship may issue notice first to the respondents as we lost contact with the respondents.
You are appearing for whom?
Respondents, Your Lordship.
While you are appearing, we will waive notice.
Okay, Your Lordship. Actually, my name is appear on the cost list, Your Lordship.
Sorry?
My name appear in the cost list, Your Lordship, so I'm appearing.
Yes.
So I pray that Your Lordship may issue notice first to the respondent as we lost contact, Your Lordship, with the respondents.
Let him serve a copy of the application upon you.
Okay, Your Lordship.
Why formal notice again? You are appearing. Hmm? This matter.
Lead matter, my lord. Lead matter came before your lordship on 20th November.
This is a similar matter.
Yeah, I arising out of
Please come
common
here.
wisdom.
Who appeared for the respondent at that time? You please answer my question. That is why notice has been directed to be issued. Today, who is appearing? Is the formality required? Once again, in order that you will serve a notice. There. As the respondent is represented by learned counsel, service of the miscellaneous application, on the party is waived. Are you ready in this section 5?
No, Your Lordship, I haven't received the.
Learned counsel for the appellants will hand over a copy of the petition to the learned advocate representing the respondent. Just hand over a copy in course of today. List this appeal along with the miscellaneous application. With similar matters which are posted for hearing on 5th December 2024.
Grateful, my lord.
5th December, this will also come.
Great.
From the main list, item number 1.
Much obliged.
Which? This is the list.
Huh? Monday, then you may request.
This is item 3. All similar.
Huh? No, he's yet to be admitted. Yes.
May it please your lordships. Well, in this case, I am appearing for the sole respondent, my lord. Today I'll seek some accommodation, my lord. I could not prepare, my lord. I was not well. I could not prepare the brief. If your lordship take it up next Monday, my lord, or any day of next week. This is for admission.
Lordship, yes.
Your appeal.
Lordship, this is still appeal, your lordship, yes.
The only thing, my lord, the problem, this person, respondent, she has already gone on retirement. So, my lord, taking, my lord, the pendency of this case, what I fear, my lord, they may not settle my things. So, these will require an RD disposal. Because my pensions are yet to be settled.
Without an authority officer.
First week. First week, lot of matters are there. Yes. All right. On the prayer of learned counsel on the prayer of Mr. Sen, learned counsel appearing for the respondent.
Yeah. Proceedings of the
This appeal and the connected miscellaneous application are adjourned till 3rd December 2024.
Lordship. Apply, your lordship.
Item number 2.
May it please your lordships. Lordships, I seek this honorable court's indulgence. The conducting counsel for the respondent could not appear before this honorable court today. So if this matter could kindly
This is the second time you are asking for adjournment.
No, lordship. I have appeared today for the first time in this particular matter. I have never appeared. So if this matter could kindly be taken up on 3rd of February, lordship.
3rd of February.
If your lordship, if it is convenient for your lordship.
Is ready for hearing.
Lordship, I am not aware about the facts and circumstances. They could not come, so I have just been requested to make a mention before this honorable court. That's why I seek an accommodation.
Yes, please.
Lordship, since my friend is asking time and I have nothing to say here, but deferring the date to February, what date you said? 3rd of September.
3rd of February.
February. I have no objection,
After
Lordship.
3 weeks.
But the matter was very much mature to be heard today itself.
No, it is up to you. If you want it to be heard this side of the vacation, please tell us.
Then I may be allowed to proceed, Lordship.
No, today she is not ready.
Lordship,
I
in fact,
thought-
I'm not an advocate on record also in this matter. I'm just appearing as a
All right, on your undertaking to file a wakalatnama.
lordship.
On your undertaking to file a wakalatnama, we can entertain you.
Lordship.
But then 3rd February is a very long adjournment.
Lordship, this is just the instruction I've received. If your lordship wants to fix it before vacation, I'll intimate it to them.
You talk to your learned friend. We have no interest in the matter. If he wants expeditious hearing, it is up to him.
No, for me, Lordship, if it is on the February, I have no objection.
All right. Learned counsel for the appellants. You're for the appellant.
For the respondent, lordship.
Okay. Learned counsel for the respondents. is entertained on the express undertaking to file a wakalatnama in this court by this week.
Lordship.
Full stop. She prays for a long adjournment of this appeal till 3rd February 2024. Full stop. 25. It is not objected to by learned counsel for the appellants. Accordingly, list this appeal on 3rd February.
Deeply obliged, Lordship.
Much obliged.
Item number 3.
Your Honor, the conducting counsel of this case is
Yes.
item number 3, Your Honor. The conducting counsel of this case is out of station, Your Honor. So I request this court to give 2 weeks time, Your Honor.
But the service was not complete, my lord. It appears that they have received notice and entering appearance for the respondent, my lord. Are you entering appearance? Who is your senior?
So I don't know the name of the counsel.
On the personal ground of learned counsel for the respondent, this miscellaneous application is adjourned for the week. Only this week. Next week you ask your senior to come
Much obliged.
and to be listed on 2nd December.
Obliged.
Next.
Item number 4.
Yes, please.
Lordship, the petitioner here is a victim of identity theft, Lordship.
Victim of?
Identity theft, Lordship. Her name had been used to open fraudulent bank accounts which are not hers, buying mutual funds in her name which are not hers. She never did that, Lordship. That's why, and there's income tax notices have been served upon by petitioner, Lordship, to which petitioner was not aware of also. She retired as a director of soil in the government of Meghalaya, Lordship. Lordship, she was like respondent number 9. He is a bank evaluator. He is a PAN card agent, and throughout the city of Shillong, every bank, every establishment knows him very well, Lordship. And he happens also to be the petitioner's tenant in one for some time before. Lordship, what happened in the year 2022?
Yes.
Suddenly, the respondent 9 informs her that she, from reliable sources, have come to know that there were some income tax notice against her, and she told her not to worry. She's a simple lady, Lordship. They are not amenable. The first of all, I want to bring to your notice, Lordship. My petitioner is not amenable to the jurisdiction of the income tax, as she is a scheduled tribe person, Lordship. So when she joined service, the rule is that when they join the service, Lordship, they just file their ST certificate before the concerned authority of appointing them. And it follows thus. If, Lordship, any income apart from a salary is there, Lordship, and it is beyond the slab of relaxation, Lordship, the income tax file is open, and then the income tax looks after, and it is they are evaded from paying it. Here, Lordship, petitioner never opened any income tax return file in her name. She never opened these 2 bank accounts, which purportedly seems to be in her name. She never purchased any mutual funds in her name, Lordship. but petitioner was she was a tenant, the respondent number 9. Petitioner, he was a mutual fund agent also, Lordship. She, in some part of time in 2010, Lordship, she purchased small mutual funds, Lordship, through his advice, Lordship, and those were dealt by her real accounts. Here what happened, respondent number 9, Lordship, he took full advantage of her innocence, Lordship. He opens bank accounts in his name, in her name, and in every bank account, the Lordship will find his email ID, his phone number. Lordship, then in the year 2022, he informs her that there was some
You
income.
used to work in that bank?
No, Lordship. Me, Lordship.
No, the respondent.
No, he was the evaluator of that bank, Lordship. Every bank personnel knows them very well. Lordship, in the charge, the police has filed a charge sheet. I have a copy of them, Lordship. Even
The evaluator of the bank.
he was once upon a time, Lordship, he was the only evaluator for the state of Meghalaya. He is very excellent in evaluation, Lordship, and in all advice of evaluation. Nearly all the banks knows him very well. He is very, very well known throughout the bank people, Lordship. So, Lordship, then 22, he informs me that from reliable sources he comes to know there's some income tax notice, and not to worry, he'll take care of. He'll call a person from Tripura who is expert in income tax, and she has to just sign a petition, Lordship. First, then second of time, he said the same thing, Lordship. Then the review petition was filed. It is not easy to believe this, Lordship, but it is true. She was in panic, Lordship, because she never had that income tax liabilities on her. She was so scared. She trusted respondent 9 because he was very close to her because he was tenant of her also, Lordship, and she never could have doubted her. She files a review petition before in her name, a review petition is drafted, and she just signs it without going through it. Only after signing it, she somehow tried to procure a copy of the same, and when she found out the mutual funds in crores of rupees were purchased in her name, Lordship, and she immediately.
This is a writ petition.
Lordship, here I'm not on this point, Lordship. I'm on this that in spite of I filed an FIR, police investigated the case.
This is a writ petition.
I'm here only with my limited prayer, Lordship. Now before
Why before this is entertainable by the division bench?
Lordship, yes, tax matters is always by the division bench here, Lordship. And Lordship, my limited prayer is not with all this. Charge sheet has been.
All tax matters or tax appeals only, 260A.
No,
Customs appeal.
No, because I'm not an Lordship, at the very outset, I submit I am not an income tax assessee. I am not amenable to any income tax proceedings. Here, my limited prayer is, Lordship, in spite of as soon as I file an FIR, I put it that nowadays the income tax is a faceless thing, Lordship. You cannot go and meet any officers. I personally, because that income tax portal, that number to log in also was not made by me. Somehow I procured it through his chartered accountant whom he took me to meet, Lordship. And after getting that, only I came to know. So first, initially, I submitted through post office, Lordship.
Where are the rules regarding entertainment of writ by the division bench? All tax writs are-
My Lord,
The writ rules. 226 rules. There are no separate article 226. Got it. We can say all matters related to tax and revenue.
Don't follow that.
This.
Lordship, initially when I came to know these are not for my writ petition, but I want to draw the attention of this court before I go to my point, Lordship. When I came to know, when I got hold of the withdrawal petition, when I got a copy of the withdrawal petition after I signed it, Lordship, I came to know it was not my mutual funds it was there. It was some new mutual funds which I never purchased, Lordship. Immediately, I went to those mutual funds office, Lordship, and I found mutual funds were purchased in my name. Then I go and that mutual funds were linked to some bank accounts. I go to the banks. I come to know that in my name 2 bank accounts were opened, Lordship, without my knowledge, without my
filed affidavits.
Lordship.
They have filed affidavits.
Lordship, they have filed. Only the state was supposed to.
I'm representing respondent number 7, the bank where the bank account was open. I would like to bring to your Lordship's notice. There was earlier a writ petition was filed by this petitioner in connection with the same matter, where this honourable division bench has already held that this is a matter that fraud and forgery, whatever she is alleging, this is a matter for a civil court to decide. My lord, I may be permitted to read out that operating part of the order.
Have you filed an affidavit?
I have filed an affidavit. I have enclosed this order also, my lord. There is no rejoinder has been filed by the petitioner to our affidavit. This honourable court, my lord, at para 5 of the earlier order has observed, since the basis of the petition is that petitioner's signature was forged or fabricated by a third party, such disputed questions cannot be gone into in proceedings under Article 2 to 6 of the Constitution, which are generally conducted on affidavit, evidence, and in a summary manner. The appropriate remedy of the petitioner would be to challenge the actions of the alleged forgery before an appropriate civil court. And on that ground, the writ petition was disposed of, merely. So in view of this observation of this honourable court, my lord, till date no civil suit has been filed by the petitioner challenging the forgery of the signature and everything. Lordship,
You see, if it is to do with income tax
Yes, my lord.
or income tax act,
Yes.
the suit is specifically barred by the act.
My lord, so far as
You
the
check up the act.
yes,
There is a specific provision which bars. So if this kind of forgery and fraud and etc. is connected with some income tax issue, so the civil court has no jurisdiction.
No jurisdiction.
Completely barred. So the
Lordship.
question is just whether it should go to the officer empowered.
Yes.
Hear the
so, but
dispute.
so far as this forgery matter is concerned, my lord, that is not
No,
yet
No, not yet
There are
challenged.
3 tiers: assessing officer,
Yes.
commissioner appeals, and then tribunal. It has to go by that route.
My lord, my lordship. Here, lordship, I stated in my application that I filed an earlier writ petition, but this writ petition is filed because of two developments. There are two orders by the Income Tax Department which did not allow me to withdraw that petition, which I have a right under the fundamental.
Income tax has initiated what kind of proceedings?
Lordship, that proceeding was in my name for somebody else.
That's all right, but what is the nature?
Lordship, for demanding for final demand.
For concealing your income.
Lordship, they asked me to pay the demand, Lordship. Why? How can I pay those demand which is not mine, Lordship?
But then you have to go and satisfy them.
No, Lordship, I tried my best. Even through emails, I have said them, give me personal hearing. But they did not answer to my talk. That's a faceless, this entire whole of India, Lordship. The thing is this, from which place it comes, we don't know. But these two impugn orders are passed by this Shillong Income Tax Department, Lordship. Lordship, after I filed an FIR, Lordship, although this is not important for this matter, I would like to bring to the notice, Lordship, I have the charge sheet. Lordship, his signature and my petitioner's signature was taken before the magistrate.
You are a director in some government department?
Yes, Lordship, just recently I retired.
In a government company?
No, Lordship, I'm the Department of Soil. I retired as the director, Lordship.
Then?
Lordship, we are exempt. Lordship, one thing, Lordship, if any of these...
No, if you exempted, it is all right, but you are not kind of a illiterate woman or
that is one
who
thing.
is deceived.
Lordship, I understand.
And,
but no, Lordship, except that withdrawal petition without reading, nothing she knew. She was not it was not in her knowledge, Lordship. As soon as she comes to know, she files an FIR. Lordship, in FSL report says, those signature, even the checks have been procured from the bank's, Lordship, checks where he signed, all where the signature of the respondent 9 according to FSL report, Lordship. None much my petitioner's signature, Lordship. All of them, even opening the account forms were also procured by the police. Opening account check issued, every signature was his, Lordship. Lordship, this is the copy of the charge sheet, Lordship. That earlier petition I filed in a very immature state, Lordship, that it may be done away with because FI is there. Now here, Lordship, when a criminal case is pending,
you
Lordship.
understood, yes, what do you say?
My Lord, I am found on behalf of respondent number 9. My Lord, this...
Who is respondent number 9?
Respondent number. My Lord, this writ petition...
Who is respondent number 9?
Nirmalia Das,
Nirmalia.
that the bank evaluator, Lordship, who had done the fraud.
No, who's for the Income Tax Authority?
They
My
were
Lord.
here today, Lordship.
You give them notice, please.
They were here, Lordship. They
My
filed
Lord.
the affidavit in opposition also.
My Lord,
They are not here today.
They are not here today.
Yes, you give them notice. We will take it up day after tomorrow.
no, my Lord, this is the petition, writ petition under Article 226 of Indian Constitution. Here, if you, my Lord, your Lordship order dated 22/9/2022 is alive, then question of any fraud or forgery cannot be raised here because already the petitioner admitted in his petition, this petition, though he has concealed and he has suppressed the fact of earlier petition, this order clearly mentioned that petition was dismissed without prejudice and asked the petitioner to go to the appellate court or lower court. Accordingly, petitioner already filed an FIR. The respondent number 9 was in custody, 79 years, senior citizen. He was in custody for about 8-9 days. The petitioner admitted that the final report was submitted by the police and the case is under trial regarding fraud and cheating, etc. So, in writ petition concern, if this order is alive, I think your lordship will not bypass the earlier order of this learned court. And here, only the petitioner can submit regarding the writ petition under Article 226 of the Indian Constitution. Article 14, Article 19 and Article 21 is to be discussed here. Rest, it as your earlier order.
Understood.
Sir.
Either she is absolutely innocent,
Sir, how your honor, sir?
or you and she colluded at one point of time, and now that she is caught, you are trying to escape.
No, my lord. No, my lord. This is not
income tax.
I may be excused.
So it might be any three of the possibilities. So let the income tax department come. Let us hear them.
Lordship, may I just submit, Lordship?
My lord.
If I have at all colluded, Lordship, there was nothing for me. I could have just gone with 10.
My lord, that will be decided by the court
Lordship.
under trial.
If I would ever...
Final charge sheet was submitted.
Lordship.
My lord.
Director of the government is not a babe in arms.
Yes,
Lordship,
yes.
only that
He is not a baby.
Lordship.
And neither bank officials or everybody is fearful of his or her job.
Lordship, even
That without any identity.
Lordship will come to the bank officer. Lordship open
These days.
Lordship charge sheet. The bank employee says the bank manager, he was online investigated. He put its statement. He never saw Ibashisha Rinja in his one. He knew Nirmalaya Das Gupta. It is state in the charge sheet, Lordship. If ever she had colluded, Lordship, she would have just come under 1026 and nothing, no income tax has to be paid, Lordship, whatsoever. Even 3,000 crores also she is exempted because she is a civil tribe.
All the more reason why while there is a possibility of her becoming a reservoir for somebody else's money.
No, Lordship. If it was at all that, I could have taken some gain from him, Lordship.
Or somebody else's investment.
No, Lordship, nothing.
Let the income tax department come.
Lordship.
My lord, case may be...
No, my lord, not day after tomorrow you.
Lordship.
Day after tomorrow, sir. It is for me, I have come from Tripura.
So 1 month was gone like that, Lordship.
1 month maybe.
Last time he had taken a date, my senior colleague. 1 month time was given for him to
All
come.
right, you come tomorrow.
Lordship, may I
Sir, I have got other
Lordship, may I pray, Lordship? Because 27, 28, 2 matters are fixed in the Guwahati High Court, Lordship. Let it be on 29.
Sir,
Lordship,
I have got some other preoccupied. Sir, maybe after 1 month.
I never asked for a date in this case, Lordship. Never. This is the first time.
Sir, I have come from Tripura, sir. I have got other
All
appointments.
right, but then it is not an arbitration that you will spend the diary and give dates.
Okay, my lord.
You will first pick up the
Then tomorrow you can...
Lordship,
give
tomorrow.
notice.
Lordship, 29th, Lordship.
29th is a problem. We will take it up.
Not 27 and 28, Lordship.
No, we will take it up second week of December.
Lordship,
Find the views.
Lordship.
11th December.
Lordship, I will be taking I already purchased my ticket. I'm taking my mother for treatment in Delhi on 5th. So, Lordship, let it come after the vacation. Till then, Lordship now knew this demand. Now, Lordship will protect me. Lordship will protect me, Lordship, because their new notices have come after I filed this, Lordship. They will, at any time they'll come and confiscate my property, Lordship. No coercious thing should be taken. Only that much, Lordship. No coercion should be done against me, Lordship. Till then, Lordship. Till that next day.
Did you take out a formal application? Because
Also, I have prayed in this my petition, Lordship. I have prayed an interim prayer.
those notices were annexed to the petition.
No, these are new ones, Lordship.
Then you have to, unless there is change of circumstances, how can we pass an interim order? Please try to appreciate.
Lordship.
At the time of admission, no interim order was passed.
No.
So you have to show some change of circumstances.
Lordship, Lordship, may I pray, Lordship, let it be fixed before 5th any day, Lordship, next month, 2nd, 3rd.
My lord,
All right.
I have got the preoccupied because I am to go for the treatment of my wife referred by the doctor. In AIMS, I am to go. I will back after the second week. After 11 or 12 or 13, any day.
When will you be back from the
Lordship, that interim application, if I move, my landed phone won't be affected, Lordship. It is due against the income tax department.
No, maybe,
it come on
maybe, my
end
lord,
of December.
because this is the, this writ petition. Here, the other matter cannot raise.
Lordship, I'll be back by the time I'm back in winter vacation here. But I need a protection. That's why before going also I can come any day. Lordship. 1, 2, 3, 4, except for 2 and 3 also I'm there, Lordship.
Where will you be on the 3rd?
No, sir, I've been AIMS in Delhi for treatment of my wife's, my lord.
Last time also same prayer.
No, not same here.
Last
Last time I told I had come from Tripura.
Oh, you said you were going to go.
No, you said you are in sick, but my learned sister,
this petition,
within a second, she became
this
like a
petition which I'm praying is not against him, Lordship.
I have got no
In this whole petition, Lordship, I am against the income tax. Only I have to make them necessary party, so I have made them, Lordship. There are 2 impugned order of the income tax which I am challenging in this petition, Lordship. That they did not allow me to withdraw the petition and they did not give any speaking order on those.
The day after tomorrow, we are.
No, sir, tomorrow I am going to Delhi. Sir.
No, you cannot.
My lord.
Somebody else will do it. Tomorrow I am going to Delhi, 3rd to 14th.
No, then tomorrow I can appear before your lordship.
Lordship, tomorrow I'll be there.
Yes, you come.
Oh, Lordship, I'm so sorry. Tomorrow I have a matter before you. The day after tomorrow, I said 28th. I have matters here tomorrow.
Yes, tomorrow you.
Yes, Lordship, I'm here.
So kind of you tomorrow, sir.
Yes.
Please.
List this writ petition for further hearing on 26th.
Lordship, on the last occasion, Lordship had directed the Income Tax Council to appear in person.
Advocate on record for the petitioner is to give immediate notice of this order to the Income Tax Department stroke its panel counsel. By physical or electronic mode or both. Give immediate notice.
Lordship.
So kind of your lordship.
Item number 5.
But ultimately you have to go to the Income Tax Department.
Lordship, let them hear me. Lordship, I am ready to face any kind of investigation.
This court has got no jurisdiction to
No, Lordship, only that.
adjudicate our income tax matter.
Lordship, jurisdiction is only on the UPN order, my right to withdrawal and non-speaking order.
And also whether you are exigible
Yes, Lordship.
to taxation
Lordship.
under the Income Tax Act, that question also will be before the.
And then Lordship, to make it clear, Lordship, I only saw I saw only SFIO. That is an investigation when a company for fraud and all, but it cannot be covered under income tax. But any kind of investigation, Lordship, CBI won't come, but apart from that, any investigation I'm ready to face. And Lordship, the police in the charge sheet says they're even investigating, they have signed a supplementary case, they're investigating the money trail where the money entered there. And they found something there, Lordship.
Say, for example, agricultural income is exempt.
No, not agricultural, Lordship.
Please listen.
Yes. I'm sorry, Lordship.
Whether it is exempt or not, it is for that department to decide.
Lordship.
It is not the writ court who will decide this.
Yeah, Lordship.
So you please consider that, give notice, come back tomorrow.
So kind of.
If I'm out of station, I'll try to file my interim application also. Oblige, sir.
My lord.
Wait, please, Your Honor.
Please, Father. We are making it easier for you. Leave is granted to the petitioner to file a supplementary affidavit,
Lordship.
bringing on record some subsequent notices issued by the Income Tax Department. In course of today, and
I'm outstation, I'll have to find.
whatever you want to do, you do. Don't create problems all the time. It's option is yours. You do it. You don't. You don't. So that you can rely on those documents tomorrow, and serve a copy thereof on the respondent.
Obliged, Lordship.
Yes. Yes, please.
May it please, Lordship. Your Lordship, this is the appeal filed by the state, my lord, against the decision of learned single judge, my lord. In the meantime, my lord, parties have been trying to settle out of court, my lord, because this is relating to resettlement of colony or people who are on the government land, my lord. We have approached the Ministry of Defence, Government of India, for allotment of some land so that they can be settled, my lord. The process is taking some time, my lord. So I am praying another 4 weeks, my lord, to settle this matter with the respondents, my lord.
This is item number 3 onwards.
5.
5, my lord.
5. Only 5, my lord.
All right. On the prayer of the learned Advocate General that efforts are being made to settle the dispute between the parties, list this appeal on the second Wednesday on reopening of the court after the Christmas vacation.
Grateful, my lord.
Item number 6.
This appeal and the connected application. No? This is the last matter.
May it please your lordship.
Yes.
Yes, my lords. In the last occasion, Honorable Lordship was pleased to question under what provisions retrospective promotion can be given to the respondent, my lord. For that, I would like to answer from the affidavit in opposition which has been filed by me, my lord. Affidavit in opposition already on record, my lord. At batch 25, my lord. If my lord will kindly allow me to take the reference. Affidavit in opposition, my lord. At page 25. Annexure R1.
Another file.
Yes. Annexure R1, page 25, my lord. May I read, my lord? Annexure R1 at page 25.
Page?
Page 25, B5, my lord.
Yes.
Yes, my lord. Here the provision for time for permission has been given, my lord. So I will read out from the notification as it is given, my lord. Yes, the Government of India, Ministry of Personnel, Public Grievance and Pensions, Department of Personnel and Training, New Delhi, dated 9th November 1998, my lord. Yes. Office Memorandum. Subject. Flexible complementary scheme for scientists in various scientific departments. recommendations of the Fifth Central Pay Commission for modification of the scheme regarding, my lord. The undersigned is directed to say that in Chapter 51 of its report, the Fifth Central Pay Commission has made a number of recommendations for modifying, in the next page, my lord, the existing flexible complementary scheme in operation in scientific and technological departments for in situ promotion of scientists, technical personnel, with a view to removing the shortcomings, inadequacies in the scheme highlighted by the Commission. The recommendations of the Fifth Central Pay Commission in this regard have been examined in consultation with the secretaries of the Department of Science and Technology and some major scientific departments, and the following decisions have been taken, my lord. I will, in order to make my submissions brief, I will take you to the specific point at batch 30, my lord, batch 30. Batch 30 and Bharat 3, my lord. May I read, my lord? Batch 30. My lord, yes. The recommendations of the Pay Commission that the existing disparities in the operation of flexible complementing scheme in various scientific and technical departments in the matter of designation of boss, the number of pay scales and the residency period should be removed, and there should be uniformity in this regard has been accepted. Accordingly, all the posts covered under the flexible complementing scheme shall carry the following uniform scales of pay designation and the minimum residency period linked to performance, my lord. And now in the next page, the scheme, the policy of promotion is given, my lord, at page 31, in the next page. At page 31, my lord. At page 31, in the next page, the scheme, the policy of promotion is provided, my lord. My lord. Next page on page 31, my lord. If I may be allowed to read, my lord. Here it is given, my lord, as per the chart, there is the scale of pay, the designation, and the minimum residency period linked to performance, my lord. So here, for a scientist B to be promoted to scientist C, the scientist B should have completed a minimum residency period of 3 years, my lord. It is given in the third section, my lord. Scale of pay, designation, and minimum residency period linked to performance. So for a scientist B, he should complete at least 3 years in service in order to be promoted to scientist C. And for a scientist C, he should complete 4 years to be promoted to scientist D. And such is the structure that is provided, my lord. So, the present respondent was appointed as scientist B in the year 2002, my lord. So his next start of promotion was supposed to have been given by 2006, because the residency period is 3 years, my lord. But in the Annexure 3, the record has been provided in Annexure 3. Yes, my lord. Yes, my lord.
My lord, if your lordship permit, I have prepared a chart, my lord, for the convenience of your lordship, my lord, just to place the facts and the relevant rules, my lord. My lord, his second promotion to grade D, my lord, which was granted to him with effect from 2015, my lord, he wants antedating of that to 2010, my lord. And for that purpose, he filed the first OA, my lord, before the tribunal.
Why 10? It should be 12. 4 years. C to D. C is 2008.
Earlier promotion was antedated, my lord. The first promotion was antedated. It was made effective from 2006, my lord.
Yes, my lord.
You missed the bus, you missed the bus. Now you cannot revert back. And in any case, you are due for another promotion in 2025.
My lord.
Right?
My lord.
My lord. The provision of law is like this. It has been decided by the Supreme Court also in the citation which I've given it annexure R8, my lord. Because my case is similarly situated to these circumstances, my lord. It is given at annexure R8, my lord. May
only one aspect I wanted to
page 58 only, my lord.
Only one aspect, my lord. My lord, what happened since 1998, there was office memorandum covering the field, my lord. In 2015, the proper rules under Article 309 came into force, my lord. Office memorandum also nowhere provided, my lord, that there should be retrospective promotion. My friend was referring to 98 office memorandum. Nowhere it says that the promotion can be retrospective, my lord. And now 2015 rules are very categorical, my lord. Rule 1214 and Rule 1215 that there cannot be retrospective promotion.
Who on that date is in which post for how many years will be considered for further promotion? That's all.
My lord.
Yes, my lord.
Yes.
And we are referring to one Supreme Court decision, my lord. There, even the tribunal has relied totally on. Now that Supreme Court decision is of 2012, my lord. The rules have been amended in 2015.
See what he says. Please kindly take your seat.
My lord.
Yes.
Yes, my lords. In the Supreme Court, because my case is similarly situated to this case, in Annexure R8 and page 58, the Supreme Court has given a detailed guidelines as to why a promotion should be granted retrospectively also, my lord. In order to antedate the promotion to the date of promotion, my lord. So here it is given, the decision was, it is at annexure R8, batch number 58, my lord. Since my case is similarly situated to this case, I have to take this reference, my lord. At page 58, my lord, if I may be allowed to read, because the whole, the circumstances and...
Yes.
Yes, my lord. The Supreme Court of India, the record of proceedings, from the judgment and order dated 5/10/2010 in WBC 14263 of 2000 of the High Court of Delhi at New Delhi. Union of India, petitioner versus S.K. Murthy, the respondent, my lord. The quorum is Honorable Mr. Justice G.S. Singh and Honorable Mr. Justice Ashok Kumar Kalkuli, my lord. I'll come to the operative part of the order, my lord.
Yes, carry on.
Yes, my lord. Okay. The delay of 55 days in filing the special leave petition is contempt. This petition is directed against order dated 5/10/2010 passed by the Division Bench of the Delhi High Court, whereby the writ petition filed by the respondent against the order passed by the Principal Bench of the Central Administrative Tribunal, or short, the Tribunal, dismissing the original application filed by him for issue of a direction to the petitioner's hearing to promote him under the flexible complementary scheme, with effect from the date of eligibility was allowed, my lord. We in the next page, my lord, at page 59. Yes. We have heard snipped Indra Swami, learned counsel for the petitioners, and Mr. Jitendra Mohan, learned counsel for the respondent, who has entered on caveat and carefully perused the record. The respondent, who was working as scientist T in the Botanical Survey of India, became eligible for promotion under FCS with effect from 1/1/1999. However, on account of delayed convening of the Departmental Review Committee Selection Committee, his promotion was delayed. And by an order that the
Mr. Counsel.
Yes, my lord.
In this case, the employee became eligible from 1999.
Yes, my lord.
As per the rules.
Yes, my lord.
Here, your eligibility is in 2015, and you are trying to, those who were in that post for so many number of years,
yes,
will have a promotion to a higher post. But then your eligibility was not there in 2006.
My lord.
Or 8 or 10, whatever.
My lord, since I was promoted, since I was appointed as scientist P in 2002, according to the rules, I should have been promoted in 2006, but the ministry, but the respondents gave me promotion only in 2008, which later on they realized, and they antedated my promotion date from 2008 to 2006.
You tell us at that point of time you were eligible to promotion.
Yes, my lord, because the residency period is 3 years according to the rules that have been shown, my lord, here.
That is in 2015, but in 2006, what was the rule?
Yes, that's why, my lord, I am referring to this Annexure 1, which was given in Annexure 1 at page 25, because this rules was framed at 9th November 1998, my lord. This was the rules framed in 1998, my lord. On the top of it, my lord, it is given me Delhi dated 9th November 1998, my lord.
Yes.
Yes, my lord. And according to this rule, in page 31, the structure is given, my lord, as to how an employee can be promoted, my lord. At page 31. This is the structure given in 1998, my lord. What my learned petitioner counsel is referring to is with regard to the rules that was framed in 2015. So 2015 rules cannot apply retrospectively, my lord. So prior, all rules that are in force prior to 2015 should be taken up, my lord. And this is the only effective rule which has been given in 9 November 1998, my lord. And the structure is given in page 31, my lord. The structure of promotion. At page 31 of the affidavit in opposition, my lord. Yes.
You were in Group B.
Yes, I am a Group A officer. I was appointed as Scientist B in 2002, my lord. So after the residency period of 3 years, I should have been promoted to Scientist C.
There, Mr. Deputy Solicitor General, he has a point.
It's 3 years.
That before working the 2015 rule, you should have implemented the 2008 rule, effected the necessary promotion, and then applied 2015.
Yes, because that cannot be applied retrospectively, my lord. Yes.
But I'll just refer to two office memorandum, my lord, which were clarificatory to the original OM, my lord. My lord, page 83 of the affidavit, my lord. Page 83, my lord. My lord, the last 4 lines from below, my lord, in the first paragraph, my lord.
Yes.
Promotions are made effective from a prospective date after the competent authorities approve the same. This is the general principle followed in a promotion, as this principle is applicable in the case of in situ promotion under FCS as well. Then it says para 2, as a matter of fact, no occasion requiring application of promotion with retrospective effects would arise in FCS cases, as it is provided in the rules for scientific focus that the assessment board shall meet at least once a year to consider cases of its own in situ promotions. Rules notified for scientific post also contain a provision for review of promotion by the selection committee assessment board twice a year, before 1st of January, 1st of July every year. And the selection committee assessment board is required to make its recommendation on promotion, keeping in view these crucial dates of 1st January. The competent authority has to take a final view based on these recommendations shall ensure that no promotion is granted with retrospective effect. This was in 2002, my lord. Then page 85, my lord.
No, we are not saying retrospective effect. That in 2015, you should have applied the 1998 rules, if not applied earlier, effected the promotion under that rule, and then applied the 2015 circular.
No, my lord, what I'm trying to submit, my lord.
Because you had not carried out promotion in terms of the 1998 rules.
Yes, my lord.
My lord, this is what I read just now, my lord. This is pursuant to, because 98 is not a rules, my lord, that is also office memorandum, my lord.
Yes.
That has been clarified in 2002, my lord. The one I just referred to, my lord. That has again been clarified in 2012, my lord. That is at page 85, my lord.
Yes, no retrospective promotion.
No
You are not
retrospective
giving
promotion.
retrospective promotion. You are giving prospective promotion for, on 1998 notification for 2006 or 8, whatever appointments.
So here, my lord, your lordship kindly comes to the chart, my lord. Initial appointment 2002, my lord.
Yes.
So first promotion is due after 4 years, my lord.
It is 3 years. There is a mistake, my lord. There is a misleading information, my lord. According to
He is referring to the 2015 notification.
yes, in 2015 notification also it is 3 years, my lord. It is given at page. It is given at page 98, my lord, of the affidavit in opposition on page 98. There is a slight misleading information, my lord. At page 98, in the affidavit in opposition, it is shown that Scientist B residency period is 3 years. To Scientist C, it is 4 years. Scientist D, 4 years. Scientist A, 5 years. Scientist F, 5 years, like that with caution, my lord. At page 98 of the affidavit in opposition, that is in reference to the recruitment rules of 2015, my lord. I have also prepared a written argument, my lord, in support of my arguments today, my lord. At page 98 is this shown, my lord. Even after 2015 also, my lord.
Where is the 215 notification?
2015 notification
Page
is
98 is a table, my lord.
given in annexure R15, annexure R15, page 88. Page 88. And the specs
2015.
2015 rules, my lord.
Yes, page.
Yes. It is,
98, my lord.
it is given in,
Page 98 is a table, my lord.
yes, page 98 is a table, my lord. It's schedule 4, my lord, below the page. Page 98. There the structure is given, my lord.
But here, first is scientist B, my lord. Scientist B has already been appointed. So that 3 year is not applicable to him, my lord. Now the question is, will come to promotion from B to C, my lord. That is 4 years. C to D is 4 years.
All right, we've got the point. You filed written notes?
Yes. My lord,
My lord, only one point I wanted to clarify, my lord. Lordship kindly sees the chart, my lord. He has been given 3 promotions after that, my lord. The only question is of antedating all the promotion. That is what he is asking for, my lord. Now, my lord, 2015 rules came into picture in 2015, my lord. So, my lord, even if the lordship comes to conclusion that first promotion that was due to him falls within pre-2015, my lord, but subsequent promotions will fall.
No. What would be his grade or post,
my lord,
in 2015? From there, you apply the new.
Yes, my lord.
But suppose
my lord,
it was B. Should it have not been C or D?
Most probably it will be C, my lord, around that time.
You start from that.
Yes, my
My
lord.
lord, lordship kindly clarify that after 2015 rules, he'll be entitled to his.
Yes,
Yes.
on the
Yes.
grade worked out on that day in 2015.
My lord, yes.
Otherwise, also, my lord, what will happen? The earlier office memorandum provided that even if retrospective promotion is
One
given,
thing is there,
my lord,
eligibility might be there in 4 years,
my lord,
but you have not given him for 8 years.
Yes, my lord.
It may be your discretion also. It is not a matter of right.
Yes, my lord. My lord, yes.
We don't think that is a matter of right.
Yes, my
Your
lord.
eligibility becomes.
Yes, my lord. And then in all the succeeding years, no interview was held for me to appear for the necessary promotions, my lord. Because of which even the Supreme Court in their judgments have given, which I've taken the reference, my lord. The judgment of S.K. Murthy and then the judgment of yes, my lord. I have given everything in the written argument that I have just submitted, my lord. My lord.
All right.
my,
By when you will submit, Mr. Muzika?
in 2 days time, my lord.
All right. Hearing concluded. .cav. Learned counsel for the respondent has tendered written submissions in court today. Dr. Muzika, learned Deputy Solicitor General, will file written notes on behalf of written submissions on behalf of the appellants by 27th.
Well,
Much obliged, my lord.
deep.
You said this one came, huh?
Thanks, sir.